Deputy O'Riordáin.
Thanks, Chair, and thanks for the presentations. And much of what I was going to say has already been ably put forward by my colleagues on the committee, and it's great to see such a uniformity of views really around the issue and issues at hand. Again, just to welcome the bill, I think in fairness there's a lot to recommend itself about the bill, and I think that a huge amount in it is broadly welcomed. But again, coming back to the same issues again, in relation to, there's a few of the things I just want to reiterate what has already been said. The age issue is going to be a problem. I think what this bill needs is surgery, not butchery. But at the same time, I do feel that if this bill remains as it is, that it's going to open up a huge amount of legalistic and constitutional minefields. And I think it could spend an awful lot of time in the courts. And I think if together we could view this as a kind of eroding process, that, and we could work with this bill as it goes along, rather than viewing it as an end product that has to be accepted or rejected. I think it would be better if we did it in that way. On the divorce situation, I think it's hugely constitutionally questionable, considering, as what others have already said, that the family is at the heart of the Irish Constitution, and to suggest that a family would have to break up and a divorce situation would be forced from the state onto a family, I think is very constitutionally questionable. I can see a case being taken as High Court, Supreme Court, and being easily won, in my view, and I'm not a constitutional lawyer, on that basis, considering the way that the Constitution is written and the interpretations that have been made in the Constitution down through the years, and the fact that we would have to wait for a referendum on marriage equality, which could, as Sarah quite rightly says, be accepted or rejected, I think it's a constitutional nonsense. And in my own view, the idea that the state would force on a couple to dissolve their marriage against their will doesn't have any constitutional standing. And I think every piece of legislation that goes through these houses, these erectors, have to be in adherence with the Constitution. On the children's issue, and I'm taken with the representations of from TENI and from LGBT Noise and other groups as well, on the children's issue, and mindful of the advice given from the Ombudsman for Children, I think again there's a huge legalistic problem there in terms of that age. I mean, there's many who would advocate there shouldn't be an age bar at all, but certainly the age group between 16 and 18, I think is the recommendations here in the bill are hardly questionable. Again, the supporting documentation. I mean, are we really advocating that we'd have a difference of opinion between somebody's gender identity and what somebody else says? I mean, I think that's again open for a huge constitutional and legal argument over that. I mean, and finally, on maybe it's a minor point in the legislation, but I think the piece about sport is bordering on bizarre. I mean, who are we as a legislative body to tell sporting organisations or to recommend who or who can't play what sport? I find that really, really just strange and odd and completely unnecessary and slightly offensive. I mean, we're still trying to amend legislation 12 years ago that was brought in good faith to allow certain bodies the right to, inverted commas, discrimination on basis of religious ethos in employment law. And we're changing that now because you see that the context has changed. But I think something like that, is unnecessary and as I say, bizarre and offensive. And I don't necessarily, in as much as it is very strange for the state to require a divorce of a couple that clearly are very strong and committed to each other, the state would demand what sport a person can or can't play. I find that quite objectionable. But I'd be interested in hearing your reactions to what I've said, which is very much in agreement with other colleagues who've said here. But I also the broad point I want to make is that I hope that what we have here is a process and not a fait accompli. I hope what we have here is a rolling, living, evolving bill that can be amended and changed. And in terms of saying, well, the government have said 18 is the final decision, I hope that there'll be leeway there for that to be altered. But the final point I would say, just to reiterate, I think if the bill stays as is, without the surgery, as I said, rather than the butchery that we can do here, then I think it actually would be butchered in a constitutional court with a case taken by somebody. And I think we should prevent that from happening by amending it here. Thanks, Chair.